Justice Clarence Thomas, among some, is one of the most respected men in America, and clearly, among others, is one of the most reviled. That there are such dramatically different views of this one justice demonstrates that we really do live in two separate realities. Today, I am pleased to welcome Judge Amul Thapar, author of The People's Justice, Clarence Thomas and the Constitutional Stories That Define Him, whose book describes what a principled legal scholar and upstanding man of character Justice Thomas is. I'm Julie Hartman, and this is Timeless. Hello, welcome everyone, new and old, to Timeless. I hope that you are having a great week. Just a reminder to hit the subscribe button down below so that you can stay notified every time I post a Julie Noted news video or a Timeless episode. And also be sure to follow me on Instagram and Twitter at Julie R. Hartman. Today, I am honored to welcome the author of one of my most recent favorite books, The People's Justice, Clarence Thomas and the Constitutional Stories That Define Him. This is Judge Amul Thapar. He serves as a judge on the United States Court of Appeals for the Sixth Circuit. Before joining the bench, Judge Thapar served as the United States Attorney for the Eastern District of Kentucky, and he also teaches courses on originalism, the Federalists and Anti-Federalists, and legal writing at Notre Dame Law School, the University of Virginia Law School, and Vanderbilt Law School. Hello, Judge. Welcome to Timeless.
Thank you for having me. It's a pleasure to be here.
Well, it is a pleasure to have you here. And as I told you before the show, I was so impressed with your book for a number of reasons. And I think that you achieve two very important things. First, as I said in the introduction, you convey what a principled and deeply good man Justice Thomas is, but also you teach the reader so much about constitutional law. Just for the audience, I'd like to tell you that Judge Thapar structures the book by looking at several different cases, I believe 12 total. So again, if you want to get both of these things, a look at Justice Thomas as well as really a history of a recent constitutional law, this is the read for you.
Yeah, and the goal of the book was, in the introduction and conclusion, to tell the reader what I think, kind of lay my cards on the table. I'm an originalist like Justice Thomas, and while not all originalists are alike, and we can get into that, I think that his originalism is one that honors the will of the people, as I say in the introduction. But in between, I let the reader determine for themselves if I'm right or wrong, and just tell the 12 stories of the 12 cases that went to the Supreme Court that kind of laid this theory out.
Before we go into some of those cases, of course, we won't have time, as much as I would like to go through them all. So I'll ask you to identify what you view to be the most important. But before we get to that, why did you write this book?
You know, when Justice Scalia sadly passed, he talked about the obligation to fly the flag of originalism. He didn't believe it was being done in the academies. He thought judges and others, lawyers that believed in originalism, had a responsibility to do it. When I wrote the first version of this book, I wrote a book called Originalism for Lay People. I gave it to my wife, as most spouses should do when they write something, and she almost threw up. She said, "Who's going to read this stuff?" And so I was back to the drawing board. But what I found in studying that and trying to write a book that ordinary Americans would understand is that, A, the stories of the cases are fascinating, and B, Justice Thomas not only is a very, very principled originalist, as even his critics admit, but that he cares passionately about people, the real people involved in the case, and every one of his decisions reflects that, and that is contrary to what you'll hear out there. And what I discovered that was so fascinating is that he has a very strong Black voice that also shines through in his opinions, but is rarely reported on.
Yes, you argue that very well. Could you please provide us with a brief synopsis of the really fascinating upbringing of Clarence Thomas? How did this man come to be formed into the person that he is today?
Yeah, and I think that relates to something. So I'm going to just quickly go through that, but then I want to tie it to one of the criticisms of him that's so ironic, which is Justice Thomas was born and raised in Pinpoint, Georgia. He's a was born to a single mother who was making $10 a week. She was making so little she couldn't afford to raise a young Clarence Thomas and his brother. So she gave them to their grandfather, who ultimately raised them. And their grandfather believed fundamentally in the value of an education and saved every penny he had. In spite of just having a third grade education, he understood that the one chance for Justice Thomas and his brother to get out was to get a good education. And so he saved enough money to send them to a K through 8 Catholic school. And at this Catholic school, Justice Thomas, as he himself admits, was very influenced by the nuns there and the teachers there and how much they cared for him, and became just a top student at the school. And this was in spite of, as I mentioned, his grandfather only having a third grade education. He had to work hard, and his grandfather could barely read, and yet he understood this. It was really interesting because Justice Thomas, every time he complained that he couldn't do something, his grandfather had a saying, and the saying stuck with him, which is, "Old man can't is dead. You know how I know? I helped bury him." And so it's from this upbringing where he ultimately goes to the seminary, leaves the seminary when Martin Luther King was assassinated. And I can go into that if you want, but ends up at Holy Cross, where he graduates as one of the top students in his class and goes on to Yale Law School.
Yes, and actually, for a time in Justice Thomas's life, he was an avowed Marxist, not unlike one of Justice Thomas's friends and heroes, Thomas Sowell. And it was later, I believe, and please correct me if I'm wrong, it was when Justice Thomas decided to go in the seminary that he had a bit of an ideological shift away from Marxism and towards conservatism.
Yeah, I mean, I think it wasn't only in the seminary. I think if you read his book, My Grandfather's Son,
Yes.
it was not the seminary, Holy Cross, Yale Law School, and thereafter, where he kind of shifted over time. But the one thing he had that was really strong at Holy Cross after the seminary was he was a Black nationalist as well. So, and Marxism came out of that in some ways, but he really was someone who read and studied people like Malcolm X. And you can see that at times in his jurisprudence, in that he doesn't think, he looks at every American as not being a victim necessarily, but being a victor. And what I mean by that is he wants to give every American a chance to succeed, and he believes they can by rolling up their sleeves and working hard.
Yes, and as you said a few moments ago, earlier in this interview, he has a strong Black voice in his jurisprudence and in his concurring opinions. By the way, you know this, I'm just saying this for the audience who may not have read some of Justice Thomas's opinions. They are marvelous. First of all, they're extremely understandable to everyday people who may not know anything about constitutional law. That is by design. He wants everyday people to be able to understand these topics. And also, as we see in his concurring opinion that he just released on the affirmative action case, he quotes Frederick Douglass, he quotes Tom Sowell. In that specific opinion, he gives a comprehensive history of Black-white relations, going all the way back to the Reconstruction. So this idea, as we heard, from Joy Reid at the beginning of this show, that he is somehow a self-hating Black person, somehow anti-Black, it is as bogus as it is insulting.
Yeah, I don't know for sure, but I think he reflects the views of many people in that if you look at what he said, so there's a case that's not in this book, but that I quote because he quotes it often. He has been talking about how proud he is of historically Black colleges from his first days on the court. And he's been talking about the importance of historically Black colleges. And in Students for Fair Admission, he pointed out that 80% of all Black doctors or all Black judges came from historically Black colleges, that 50% of all Black doctors came from historically Black colleges. And this was in rebuttal to, I think, your alma mater, where he was saying, they were saying, well, we're so important for the success of America that we have to have, the only way minorities are going to succeed is if we help them. And he's against that. He doesn't believe the Constitution provides for that. The Equal Protection Clause in his mind is clear that you have to treat everyone equally. And by doing so, you give everyone an equal opportunity. But as he pointed out in Grutter, as is reflected in the book, when you hold people to a high standard, they accomplish it. Similarly, when you hold people to a low standard, they accomplish it. And he thinks that it is racist to hold certain races to lower standards than other races.
Yes, and it is. It certainly is. He speaks a lot about the soft bigotry of low expectations. I would amend that. I don't think it's soft. I think it's pretty blatant, hard bigotry. But you understand the point. So let's go on to some of these cases. As I said, you do an amazing job of synopsizing them and showing how Justice Thomas, apropos of your title, really represents the people in each of these cases. You have Kelo versus the City of New London, Grutter versus Bollinger, Gonzalez versus Raich, Doe versus the United States, so many of these cases. If you could identify 2 or 3 that are the most important, what would they be? And please tell us about some of them in detail.
So let me start with the first one, which is Kelo that you mentioned. Kelo is the first chapter in the book for a reason. Suzette Kelo was down on her luck. She was getting separated from her husband. She was a paramedic. She was looking for a place to live. And she found, on a paramedic salary, she couldn't afford some extravagant house. But what she found was in this beautiful blue-collar neighborhood, she wanted a view of the water. And she found a place in New London, Connecticut, as I mentioned, a blue-collar neighborhood that was run down, so run down that the real estate agent was embarrassed to sell it to her and asked her, are you sure? Do you want to see other houses? But Suzette knew this was the house for her. And Suzette went to class at night, taking correspondence courses to become a nurse. And she did that and accomplished that. And through blood, sweat, and tears, she rehabbed the house. She made it a perfect house for her, so perfect that she painted it her favorite color, Odessa pink. At the same time she was doing this, trouble was brewing in New London, or at least she didn't know it, but New London was seeking a top corporation to move in, preferably a Fortune 500, and they found a natural partner in a company your viewers and listeners may have heard of called the Pfizer Corporation. Pfizer came into New London and was going to renovate an old mill site. And they believed they had the perfect wonder drug, Viagra, that they were going to develop there. And as they were doing that, they wanted a nice park, they wanted upscale condos, they wanted restaurants and bars and shops and everything else upscale so their executives could locate there. And in order to do that, they viewed the neighborhood Suzette lived in as expendable, and they asked the city to exercise their eminent domain power and get rid of that neighborhood so they could put in the shops and restaurants and high-rise condo. Well, Suzette and her neighbors weren't having any of it. And one of her neighbors, who has not been mentioned a lot, but I think is important, is the Dairy family. The Dairy family had lived there for over 100 years. That's how old and proud they were of this neighborhood. Every time one of their kids got married, they put a down payment on a house in the neighborhood for their kids. So when Pfizer and the city and the state government wanted to take Suzette's property and her neighbors, they were not having any of it, and they decided to fight. And I'm happy to go on if you'd like.
Please go on. This is very important.
So Suzette and her neighbors enlisted the Institute for Justice and Scott Bullock to fight the city. and they filed a motion to try and stop them. So eminent domain's found in the Fifth Amendment. It says the government may take your property for public use with just compensation. What that means is they can take a sliver of your land to expand their roads, or they can put a sidewalk in, truly for the public use. That's what it meant as an original matter. In the 1950s, there was a Supreme Court case out of the District of Columbia called Berman, and it's important to talk about this because I'll come back to it in a minute. But the Berman case, the city of D.C., or the District of Columbia City Council, wanted to get rid of certain poor areas and put in private development, apartments, condos, houses, those types of things, and even shops. And this case, the residents challenged it, because what happens when you displace poor individuals? They don't have, you give them just compensation, which of course is less than their property is worth. And they can't, as we all know, property values go up. You can't just go buy something like what you lived in before. And so they fought it because they thought they would be homeless if they were displaced. This case went all the way to the Supreme Court, and I want you to note this. The Supreme Court then, instead of using the words public use, used the words public purpose and allowed this program to exist. So now go back to Suzette Kelo and her neighbors fighting this. They're fighting an uphill battle. So what did Scott argue? Scott argued that it wasn't a public purpose because it was Pfizer's purpose. And this case went all the way to the Supreme Court. And at the Supreme Court, Justice Scalia asked a very important question in an oral argument when he was attacking public purpose. He said to the city's lawyer, does that mean you can take from the poor and give to the rich if the rich pay more taxes? And the city's lawyer said yes. And you could hear Justice Scalia being startled, and he had to ask a follow-up. That means you can take from A and give to B if B will pay more taxes? Again, the city's lawyer doubled down and said yes. And so this case then reached decision time, and it was decided 5-4. And Suzette and her neighbors lost. And the Justice O'Connor wrote the principal dissent, and she argued that Pfizer's purpose was not a public purpose. In other words, a private was not a public purpose. And Justice Scalia, Rehnquist, and Thomas joined it. But then Justice Thomas wrote alone, because he believed the Supreme Court should return to the original meaning the public use. And what you will not find anywhere if you research it is you will not find who invited him to do this. You will not find any articles about Justice Thomas's case or opinion. And it was the NAACP that asked him to do it, because most often eminent domain is used, as Justice Thomas points out, to displace poor and minorities. We don't displace the rich with eminent domain. Cities and governments often displace poor and minorities. And you don't have to believe Justice Thomas. He goes through the statistics. He shows that in Berman, 97% of the people displaced were Black. He points out in Baltimore and Minnesota these horrific eminent domain programs that existed to displace the poor. And in Minnesota, the quotes in the book, I'm not going to repeat it, the NAACP included it in their brief, and then Justice Thomas reproduced it in his opinion about what city officials were saying and what they were calling in a derogatory way with racist terms, eminent domain. He pointed out that something has gone seriously awry with our Constitution when the American people are safe in their home, but their homes themselves aren't safe. What he means by that is you can't search someone's home with probable cause, but the government can just take it with just compensation. And so it's interesting that this dissent, what I would ask his critics is go read this dissent. Tell me where he's wrong. Tell me where he's against the little guy. Tell me where the original meaning, because this is the important concept that you'll see throughout this book. When we get away from the original meaning of the Constitution, it's often the little people who are hurt, the poor, minorities, and others, and not the rich. And Justice Thomas so often is championing these people, yet no one talks about it. You cannot find, and I challenge you to do this, your listeners and viewers, go find all the glowing reports about his dissent. You won't find them. Yet, if someone else would have written it, and I'll leave to your imagination who, but pick your other justice, it would be all over the media.
So why do you think that is? Why do you think the media wouldn't focus on such a brilliantly written opinion that champions the little guy, written by
I
Justice
don't
Thomas?
know. I'm surprised, and here's the kicker, is his dissent and the dissent of Justice O'Connor was so important that 45 states changed their laws after that. But as Justice Thomas has often pointed out, that's not a substitute for the Constitution, because
Yeah.
you can go back and states can change their laws back to what they had. The laws aren't the same protection. Not all 45 have those protections. There've been some good and thoughtful scholarship on this about how those states' laws aren't as protective as the Constitution itself. The worst kicker about this is that after 8 years, Pfizer left, and I went and visited New London, and where that blue-collar neighborhood used to be, that proud blue-collar neighborhood, beautiful, proud blue-collar neighborhood, is now a barren field. And the picture's in the book.
Yes, it is. It is. I wish we could put a photo of it up, but oh well, people have to buy your book to see it, and it is well worth it. Really, even if only to just see that photo. It's devastating. You know, the irony is, if you walked up to an average student at an American college campus and you said, there was this case that came before the Supreme Court where a big corporation wanted to take someone's home, demolish that home, set up their big corporation, and the Supreme Court ruled on the side of this big corporation. Do you think Justice Clarence Thomas ruled on the side of the corporation, or do you think Justice Thomas ruled on the side of the person who was evicted? I can bet you 9 out of 10 college students will go, of course, you know, that bigot Justice Thomas ruled with the big corporations. It's the ignorance is staggering.
Yeah, and that's why I've tried to say to people, look, buy the book, read it. I think you'll find it fascinating, but give it to a friend who's a critic, right? We've
Yes.
all got friends who are critics of Justice Thomas. The thing I did in the book that you won't find elsewhere is there's a ridiculous amount of endnotes because I wanted to put all my sources in the book. So if people didn't believe it, they could go read the decision, they could go read the trial record that I read, they could go read the sources and understand that this is what was really taking place. And you're absolutely right. If we went through colleges, in fact, it'd be a ton of fun just to walk through and describe it as you did and see what people say, who ruled, which side, first to ask them, which side would you be on? And then to say, which side do you think Clarence Thomas was on?
Yes, we should do that. It would be a very interesting poll to conduct. I mean,
I'm all in. If you want to do it, I'll come with you. We'll have a ton of fun.
We will have a ton of fun. I mean, I would add so many more questions to that. I would say, which party fought against slavery? The Democratic Party or the Republican Party? Which party overwhelmingly voted in Congress for the passage of the 1964 Civil Rights Act? Democrats or Republicans? So we could come up with a whole list to quiz.
Well, I'll give you one from the book that I think is fascinating, is who was on the side of Bill Cosby's victims when they wanted to vindicate their names, and who wrote a dissental championing them, right? In the book, Kathy McKee. All she wants to do, Kathy McKee accused Bill Cosby of rape. Him and his lawyers went after her. All she wanted to do was vindicate and write her name, and she was kept out of court by a case, New York Times v. Sullivan. Justice Thomas points out again when we get away, in McKee, he writes a dissental pointing out how far away, or a concurrence pointing out how far away we've gotten from the original meaning of the Constitution and how, again, it's harmed the little person. And then 2 years later, to prove he's the people's justice, he never forgets these people. 2 years later, in a different case, and I pointed this out to Kathy, and she was so appreciative that he hadn't forgotten her. He points out that by accusing a powerful man of rape, she was barred from vindicating her name, essentially.
Yes. That's very important for people to know. I'm glad that you said that. Before we continue with Judge Thapar, I'd like to quickly tell you about My Pillow. I use all My Pillow products. I would not advertise them if I did not use them. I walk into work wearing my slippers because they are far more comfortable than heels. Then I go home and sleep on my pillows and the Giza Dream bed sheets, and you can get all of those items at a discount to boot. If you use the promo code Hartman, which is my last name, spelled Hartman, you can get 60% off for a limited time on the Giza Dream sheets that comes with a 60-day money-back guarantee and a 10-year warranty. You will receive a set for as low as $39.99 with the promo code Hartman. And on top of that, you will get Mike Lindell's soft cover book free. Just go to mypillow.com and click on the radio listener square and use the promo code Hartman, or call 1-800-566-6745 and use the promo code Hartman. Judge Thapar, could you please identify one other case from your book? I think this Kelo case that we've discussed was really powerful and important to include here. What is one other that you would like all of us to walk away from this interview knowing about?
Well, I really want to tell you about Zellman, but I'm going to save that. That's the second chapter. I'm going to let people read about it. But I really love the Zellman chapter because of all the characters, all the individuals involved, Fannie Lewis. So that's a teaser, but I'm going to talk about Otis McDonald, if that's okay with you.
Absolutely
because I think
okay.
people misunderstand this case, and I think it's important that people know Otis McDonald was from Louisiana. When he was young, 14 to 16, he moved up to Chicago to pursue a better life for himself. He enlisted in the Army, served honorably, got out on the GI Bill, and worked during the day as a janitor and went to college at night so he could provide for his wife and kids a better life than he himself had. His wife's dream was to get a house, and they bought a house in a suburb known as Morgan Park on the south side of Chicago. And it was a beautiful tree-lined street. They loved it when they moved there. Well, as crime started to expand in the South Side, gangs and drugs started to permeate his neighborhood. And Otis fought back. First, he put bars, and there's 6 different crimes his family suffered, and they're recounted in the book, sometimes in gripping drama. But first, they put bars up on the windows. They put an alarm system in. Otis joined a community group to try and stop crime from permeating his neighborhood. He then became the head of the community group, worked with police. He did everything possible to stop crime from coming into his house, infecting his kids, and it just kept coming. And at one point, his neighbor discovered someone hiding under the car in his garage. And but for his eagle-eyed neighbor who called 911, Otis wondered what would have happened. And so he decided that if people broke into his house, when he dialed 911, the police, no matter their good intentions, could not get there quick enough. And the only thing as a vet and an avid hunter that could protect him and his family was to have a pistol at his bedside. But the city of Chicago wouldn't let him do so. And Otis wanted to challenge the city of Chicago, but Heller had not been decided yet. And the book recounts Otis having to be patient and him going to read all the Supreme Court cases and all the history about gun rights in America and what happened. And the city of Chicago was fighting him tooth and nail. Finally, Heller was decided, which said the Second Amendment means what it says, and there's a right to bear arms. But that didn't apply to the states. Remember, the Second Amendment applies to the federal government. The way the rights are applied to the states is through the 14th Amendment. And there was a question as to whether the Second Amendment would be applied to the states. Well, the case goes all the way to the Supreme Court, and the book recounts how it gets there and everything else. And Otis, who was a grandson of slaves, is championing the Second Amendment rights of Chicagoans so they can possess a firearm to protect themselves from the gangs and drugs and other crime. And at the Supreme Court, there's what I call a 4-1-4 decision. I'm not going to get to the intricacies of the law, but the 4 justices said that substantive due process incorporated the Second Amendment. Justice Thomas provided the 5th critical vote for Otis to win. But here's the descendant of slaves, Clarence Thomas, vindicating the grandson of slaves, right to possess a firearm. Why is that important? Because in Justice Thomas's opinion, he goes through why the Privileges or Immunities Clause was included in the 14th Amendment. And he quotes Frederick Douglass, who was arguing that without the right to bear arms, blacks would never be equal. And he pointed out that after the Civil War, the South used what were called black codes to make sure blacks couldn't possess firearms, including 180,000 freedmen and a number of others. Anyone coming to the South that was black could not possess a firearm. So they passed the Privileges or Immunities Clause, among other things, to ensure that blacks could possess firearms. And so here you had Justice Thomas writing this opinion about the history, about the discrimination that existed after the Civil War, about the black codes, the descendant of slaves himself championing the grandson of slaves. And Otis McDonald, when he read the opinion, was so touched. While he really appreciated winning the case for his family and himself, he realized through his own studies how important it was to do it the right way. And he saw Justice Thomas's opinion as vindicating what he was trying to accomplish on behalf of all American citizens.
With each example that you give, I hear Joy Reid's comment in my head where she said, Justice Thomas has repaid black people with scorn. You have pointed out, I mean, in every opinion, in every case, when it pertains to minorities or black people, he talks about how the thing that he is advocating for is the best possible outcome for protecting black people and minorities. You just talked about this history of firearm possession in affirmative action in this UNC and Harvard cases versus the Students for Fair Admissions. He extensively talks about this mismatch, how when black students are placed in universities that may not be in accordance with their so far demonstrated academic performance, it actually leads to higher dropout rates and worse outcomes for blacks. He in the Roe versus Wade case, he talks about the history of abortion. Margaret Sanger coined the term birth control to quite literally control who was birthed. She was a eugenicist who wanted to eliminate black people as well as poor people as well as disabled people because she felt that those were people were nuisances to society. And then of course in this Kelo versus New London place, as you said, most of the individuals who are displaced as a result of government interference are minorities. So I just wanted to point that out to show you how insulting, as I said earlier, how libelous and also insulting it is for people to criticize this justice as inherently anti-black.
Yeah, and I think you've pointed it out so well, but I think chapters 2 and 3, which I didn't talk about, but Zellman and Grutter, which is affirmative action and vouchers, when you read those together, there's a reason they're together. Justice Thomas points out that the failure of living up to the promises of Brown v. Board of Education for poor minority students, and then he points out how affirmative action benefits the rich. And so for Justice Thomas, it's all about helping out people that deserve to be helped, not
Yes.
deserve, I guess he thinks everyone deserves to be helped, but the people that no one else is helping, and that the Constitution commands be given an opportunity, not giving a leg up to the rich, but giving an opportunity to the poor. And when you read Zellman and Grutter together, it's inescapable that Justice Thomas views it this way. He also has this great quote in Missouri v. Jenkins where he says, "It never ceases to amaze me that people assume that anything that is predominantly black is inferior." He's talking about historically black colleges. And one of the cases, and I'm not going to go into it, but one of the things when schools were trying to desegregate historically black colleges, and this book talks about it in The People's Justice, there was a kid who was getting a graduate degree. I guess he wasn't a kid anymore. And he was on a scholarship to Alabama State University, a historically black college. And the courts, in the name of desegregating a historically black college, took the scholarship away from him and wanted to give it only to whites. And they called it a whites only, the lawyers did, a whites only scholarship program. And you just got to read the book because you're not going to believe it. And like I said, give it to a critic or buy a copy for a critic, read it alongside them, discuss each chapter. I think even as the publisher says, even the critics will be shocked by what they think after if they give it an honest read.
Yes, and we've been focusing on these race issues because the biggest and most frequent charges levied against Justice Thomas is that he is somehow anti-Black. But as you were discussing earlier in the interview, and I'd just like to reiterate, he doesn't view himself as a Black man. He views himself as an American, as a justice for all people. He is colorblind in the best sense, that he thinks that the Constitution ought to be interpreted originally in a way that is fair to everyone. So though he often, as I said, and as you say, talks about these big issues that are affecting Black Americans, what's unique about his jurisprudence is that he's not giving favor to anyone. He is interpreting the law equally and impartially.
Right. And that's why it so often results in when you interpret the law that way, you reflect the will of the American people, right? Because the laws and the Constitution are the wills of the American people. And when you do so neutrally, then you protect people from predatory corporations like he was trying to do in Suzette Kelo. You give the kids in Cleveland a chance to succeed by giving them an opportunity to get out of failing schools like he did in Zelman. You give Kathy McKee the right to vindicate her name, and it protects all races, but it most importantly protects in so many cases those who are most vulnerable and who are often preyed on by corporations and governments.
Mm-hmm. Moving on to a different discussion of Justice Thomas. Judge Thapar, I love reading the Bible, A, for religious reasons, and B, just to understand how people think and the development of Western civilization. And I had this thought the other day, which isn't exactly revelatory, but it's profound, in that every righteous person in the Bible is tested, and often tested quite severely. And I think there's a greater cosmic point to that good people will face a lot of scorn and hatred and challenges. And that has certainly been the case with Justice Thomas. Those of us who have read My Grandfather's Son, which is Justice Thomas's autobiography, know how difficult those 1991 hearings where he was accused of sexual harassment by Anita Hill, how difficult that was for the justice to bear. And since then, I mean, as many of us know, Justice Thomas has been smeared in the media for supposedly taking donations from or favors from billionaires, and people are arguing that this is a violation of the ethics of the Supreme Court. It is not. In the case of Harlan Crow, Justice Thomas checked with the Supreme Court beforehand to see if he needed to report his relations with Harlan Crow. Also, at the time of flying on the private plane, going on vacation, there was a law that, or at least I shouldn't say a law, a provision in the Supreme Court Ethics Code that said that you do not have to report your relations with someone unless that person has to do with a past, present, or future case. Harlan Crow had nothing to do with any of the cases before the Supreme Court. The point is, Justice Thomas, time and time and time again, has been smeared wrongfully. Why is it so important for his critics to destroy him?
You know, I think at times, I don't know what the motive is of his critics. I think the problem is Justice Thomas has never, he thinks for himself, period. He will not kowtow to anyone. And I think the book kind of shows that. There are often times he writes alone, right? In both Doe and McKee, he's writing alone. He's stating what he thinks, ironically, in both cases on behalf of rape victims. But I think it's important that throughout his career, he has been very independent. He has not been influenced by anyone, any person, and they just can't believe it. As one of the things you played at the beginning pointed out, he must be beholden to someone because he can't be thinking this himself. That's That's what the critics appear to think. And yet, if they would just sit down and spend an hour with him, 20 minutes with him, they would see something completely different. If they would just read his cases honestly, I think they would see something completely different. All they have to do is pick up the People's Justice and read it. They would see something completely different. I just don't think they want to believe it. And as you said, if you go through and take each of these cases and ask, if we walk through colleges or we can walk through cities and ask people, I think they'll be surprised. In fact, when I wrote a couple chapters, I gave it to a friend of mine who thinks differently. And he said, I couldn't believe it when I got to the end, the race chapter, which we haven't talked about. Who was on the side of Angel Race and who was on the side of the government there? Mm-hmm. And I think that's the point, is we haven't done a great job of educating people about originalism, and that's our fault. That's no one else's fault. And I hope this book starts to contribute at doing that.
Yes, yes. On a final note, just because you brought up this ignorance about originalism, I'd like to quickly ask you about the differences between Justice Antonin Scalia and Justice Thomas's originalism. You talk about this in the book, but I think it would be important for people to understand, because many view those two justices as quite similar, but they have some pretty big differences.
Yeah, and one example was the Privileges or Immunities Clause that we just talked about in McDonald. Justice Thomas believed that the Second Amendment is incorporated through the Privileges or Immunities Clause. There's some legal reasons that's important. Justice Scalia did not. There were times, Angel Race was an example, the violent video game, the final one, and I'll just be really brief because I know we don't have a lot of time, but there's a chapter in here about violent video games where California was trying to restrict young people from buying violent video games. And Justice Scalia wrote the majority opinion saying that was a violation of the video game makers' speech rights. Justice Thomas wrote a dissent saying this had nothing to do with speech rights, but everything to do with parental rights. And he went through a long history of parental rights. And I think that chapter's really illuminating on their differences and the ways they approach it. But again, it's based in that what Justice Scalia said he was, and I think this is an unfair criticism of him, by the way, he leveled it at himself, ironically, is he said he was a faint-hearted originalist. And he always said, no, Justice Thomas, he's the pure one. And I think Justice Scalia was an amazing justice, but I think he himself admitted that Justice Thomas would always, no matter what, as you mentioned just a few minutes ago, rule consistent with the original meaning. And that was what he was committed to doing, no matter what the result was. And sometimes he himself doesn't like the results. But as Justice Scalia said, if you always like the results you're reaching, you're not being a judge, you're being a politician. And I think Justice Thomas just does his best to get the law right, but he doesn't. The thing that I learned in writing this book is he doesn't shy away from also pointing out the consequences of getting away from the original meaning and the impact it has on everyday people when we do that.
The book is The People's Justice, Clarence Thomas and the Constitutional Stories That Define Him. Judge Thapar, thank you so much for your time today.
Thank you for having me.
And I'll see you on a college campus soon for our experiment.
I look forward to it.
Yes.
Maybe we can wear our slippers too.
Oh, yes. I wear the slippers everywhere, seriously. And thank you all so much for joining me. We have a lot more news content and timeless content coming up, so please be sure to hit the subscribe button and check out this channel going forward. I'll see you all soon. Take care.